the Indian judiciary is not as powerful as the American system on the one hand. On the other hand, it is not as weak as the British system also. That is because we followed constitutional supremacy. And whenever there is a constitutional supremacy, there is power at the hand of the judiciary to interpret the constitution as per the demand of time. We know the Supreme Court is the final interpreter of the constitution. Fine. Also, added to that, the procedures that are used by the judiciary as an instrument to dispose of cases decides how much stronger the institution would be. For example, during that first or second chapter salient feature of Indian Constitution, or even during fundamental rights, we read about procedure established by law and due process of law. The procedure established by law comes from the British origin, has a limited power. That is because it can question only executive and can never question legislature. But due process of law is more of a liberal interpretation, wherein procedure established by law is already there, but added to that, whether the law is just or not is also checked through judicial review. As such, in due process of law, the judiciary can ask question to the executive like procedure established by law, but added to them even the legislature. Okay, so even what kind of a process is being used by the judiciary also determines the strength of the institution. Okay, see, in India we have an integrated as well as an independent judiciary. Okay, when we say integrated, it means we have the Supreme Court at the top, the High Court beneath it, and then the subordinate court at the district level beneath it. Now, all of these are integrated. So that's why it is a integrated system. When we say independent, we are basically talking about the principle of separation of power, wherein it is away, kept away, or departmentalized, compartmentalized away from the executive and the legislature. So there are different provisions given in the constitution which talks about how the institution of judiciary is made independent. We'll talk about it. Okay. Now see, the Indian judiciary, it is given in part 5 of the constitution from article 124 to 147. Okay. Now the constitution has established an integrated system. These courts, the Supreme Court especially, will study that first, and then we'll come to high courts, and then we'll come to the subordinate courts. Let's start with the Supreme Court. The Supreme Court administers as a single system of court. Single system of court means the laws which are formulated either by the center or by the state are disposed of by a single court system. Unlike the American system, wherein the Supreme Court of the state is at the zenith of disposing of cases which are related to state laws, and the other one, the Supreme Court, is only there for the central laws. That is not the case of India. Rather, we have a single court. Okay. Now, the Supreme Court succeeded the Federal Court of India. If you remember, while reading the Government of India Act 1935, we read about a provision about establishment of the Federal Court of India. The Supreme Court, the present Supreme Court, the apex court, is the successor of the Federal Court of India, which was established by the Government of India Act 1935. Okay. Currently, the number of judges in the Supreme Court is 34, including the Chief Justice of India. Okay, so Parliament has got the ability to change the number of judges, and every time the Supreme Court Number of Judges Amendment Act, there is a law which states about the number of judges in the Supreme Court, which has changed from time to time depending on the population, because number of cases adjudication would come, the number of cases which are at disposal of the court. Okay, so that's a organic linkage between the number of judges and the workload at the Supreme Court. Got it? Now, the Constitution declares Delhi is the seat of the Supreme Court. The Constitution declares it. Okay. But it also gives or authorizes the Chief Justice of India to appoint any other place as a seat of Supreme Court. But that has to happen with approval of the President. Got it? Constitution states that Delhi is the seat. Who has got the authorization? The Chief Justice of India with approval of President. Getting it? Don't intermix both of them. Okay. Now, when we see the institution of Supreme Court, we generally see two sides of the court. Try to understand, because this will only normalize the way you will remember the fact. Otherwise, there is a lot of things inside judiciary wherein you will forget the facts. So see, one side is the judges of court. The judges, the individual who sit in the court. Here also there is a division. One is the Chief Justice of India, the office of Chief Justice, and the other is the other judges. Got it? On the other side, you have the institution of court. Now, the institution of court has got two parts. One is the administrative side, wherein the court will be functioning more as an administrative unit, and the other hand, it will be acting as a justice delivery system. So, on the one hand, the function is administrative, on the other hand, it is delivery of justice. Getting it? So, one by one, we'll start studying. First, we'll start with judges of the court. Then we'll go to court as an institution. Then we'll study what are the administrative functions. And then we'll come to the justice delivery system. Got it? Let's start with the judges of the court. Okay. The first thing is the appointment of the judges. Now, who appoints the judges of the court? The President appoints the judges of the court. Okay. The Chief Justice is appointed by the President of India, along with consultation of judges of Supreme Court or High Court as he deems fit. This is what is the language of the Constitution. It says that the judges of the Supreme Court would be appointed by the President. Okay. And wherein there is the appointment of Chief Justice, the President will consult the judges of Supreme Court or High Court as he deems fit. And whenever he is appointing any other judge other than the Chief Justice of India, in that case, that particular setting along with Chief Justice also. Got it? Now, in India, there is a special system called as the collegium system. In none of the modern democratic state, you will find that the judges will be appointing the judges. Somewhere when you heard about this statement, it comes to the mind, okay, this is something against the principle of natural justice. Fine. But then there are different reasons for which the judiciary has kept the primacy of judicial appointment, as well as to maintain the independency of the judiciary. The collegium system has survived till date. Now, the collegium system is not given inside the Constitution. What does the Constitution says? The President will appoint the Chief Justice by consultation with judges of High Court or Supreme Court as he deems fit. Nowhere in the Constitution there is a term saying that he will be consulting a collegium system or a collegium for appointment of judges. Okay. So there are a few number of cases which actually talk about the evolution of the collegium system. Collegium system means like a small college. You had an electoral college for the election of the president or the vice president. Remember, that specific body will be responsible for the election of that particular office. Similarly, in case of judges also, there is a particular body by the name of collegium, which decides who will be appointed as the judge of the Supreme Court or High Court. Okay, you need not go into the detail of what happened in which case. You just need to remember that there was a term consultation. Remember, while we were talking about the appointment of judges, appointment by president plus consultation. Now, this term consultation is a problem because nowhere it has been explicitly defined what consultation is. Okay, and taking the advantage of this particular ambiguity, the Supreme Court, through many cases, has actually made an amendment to the Constitution without the legislature. Whose power it is to amend the Constitution? The legislature, Parliament. But see, with this term consultation, just with an imaginative stroke of the pen, the Supreme Court exchanged the word consultation with concurrence. Consultation is asking about your view. Concurrence is if you agree, then only I can take a step. Got it? So they changed the Constitution by the power of interpretation. So when we say that Supreme Court is the final interpreter of the Constitution, somewhere we see the positive side, that it's an unbiased, non-political body. On the other hand, some cases like this will also come up, wherein the Supreme Court will bring in some new meaning which may look like in an advantageous position to the court, but not to others. That is why when we will discuss about Memorandum of Procedure, the MOP, which is now being negotiated in the government for the future appointment, you will see there is a talk about including every other stakeholders. Why the judges only? Why not the executive? Because the NJEC was talking about executive. Then why the executive? Why not the legislature? Why not civil society? You are talking about a network era governance period, right? So how can you talk about the primacy of the government? So that is what is happening with the Memorandum of Procedure, the MOP negotiation. Okay, nothing has come out concretely of it, that what the MOP would be, but then these are the terms of reference, you can say, because the NJEC was declared null and void because of two grounds. Okay.